Hello, everyone, and welcome to Baker McKenzie's Labor and Employment video chat series, The Employer Report. The Employer Report is our series of chats focused on hot topics in the workplace. This is where you'll hear quick, practical tips from Baker attorneys on today's most pressing issues for employers as we navigate the new normal. My name is Stephanie Priel, and I'm an employment attorney in the firm's Los Angeles office. And today I'm joined by my colleagues, Robin Samuel from our Los Angeles office as well, and Jeff Surgeon from our New York office. And I'm going to chat with Robin and Jeff today about how companies can avoid discrimination lawsuits after layoffs. So let's start with you, Jeff. Unfortunately, several companies have had to face furloughs and layoffs in 2020 as a result of the pandemic, and this is still going on for some employers. So why should employers be concerned about discrimination claims after layoffs?
Thanks, Stephanie. So laid off employees have had their positions terminated, obviously, and this is different from a furlough where employees must take leave without pay for a period of time, but those employees on furlough generally have the expectation of being called back to work. While neither is good from an employee's perspective, employees who are laid off may be more sensitive than somebody, for example, on furlough because they've been terminated. And being laid off in the middle of a pandemic can be even more distressing. Those employees may not know if they'll be able to get another job given the fact that the economic situation has changed materially because of the pandemic. So there's some unique issues that we're facing these days. So therefore, employers will want to make sure that they document the process well and can show it wasn't discriminatory. It's also a really good idea before you consider or before you implement a layoff to consider other cost-cutting measures before you jump to that layoff. Things like salary reductions, furloughs, other cost-cutting measures are things that you should consider before implementing layoffs.
Thank you, Jeff. And Robin, over to you now. How should employers approach layoffs to ensure that they are not discriminatory?
Yeah, well, I think actually picking up on what Jeff just mentioned, one of the important things for an employer to be able to show if there are discrimination claims after a layoff is that it acted reasonably and fairly. So, looking at alternatives to layoffs and ruling them out if they're not feasible for the business is an important part of that process. You want to be able to show you didn't just jump straight to we're going to fire a bunch of people, but we actually tried to look at alternatives as well. If you conclude that the layoff is essential or necessary, then you're going to have to prove again that you went through a reasonable, fair process in deciding which employees were selected for the layoff and which were retained. And so we recommend you develop a step list that takes you through each step of the process. With those major steps being, you have to have a good documented basis for the layoff itself. Why is the layoff necessary? What are the financial or business reasons why you have to terminate employees? Second, you have to decide if there are any employees that require special treatment as part of the layoff. For example, employees who are on a leave of absence or are involved in military service or have been involved in a company investigation or have filed some sort of complaint, they may have some statutory protections against adverse employment actions. And while that typically doesn't mean they cannot be included in a layoff, it just might require some special handling or evaluation. Once you're in the process of actually going through and deciding which employees to include, again, it's going to be critical that you have documented neutral, non-discriminatory reasons or selection criteria that you use in your layoff. And you need to document that decision-making process. So if somebody claims they were treated unfairly or were selected because of discrimination, you can point to the evidence showing that they were not, that they were selected objectively. And for that reason, it's important to work with counsel to review your selection criteria to make sure that it is in fact a valid basis for including employees in layoffs, and you're not using subjective or hard to prove criteria that'll be easier for employees to challenge. And then finally, once you've gone through and selected the employees for the layoff, you need to step back and take a statistical look at your results to make sure that you're not having an outsized or disproportionately large impact on any protected characteristic or category of employees, such as race, age, sex, etc. And again, wise to work with counsel, do that under privilege, so that if you need to make adjustments to the layoff selections, you can do that in a protected, careful way.
Thanks, Robin. And you mentioned evaluating whether categories of employees might be disproportionately impacted by a layoff, and then readjusting the layoffs to remove that disparate impact. Can you go into a little more detail about what employers can do along those lines?
Yeah, as I mentioned, it's something you want to work with counsel on so that it is covered by privilege. And the basic analysis is, it's called a disparate impact analysis. And what you're doing is looking at the overall population of employees, and then comparing the population of the selected and non-selected employees to that overall population to see if there's some statistical deviation from what you would expect from a neutral or objective layoff. So, if you had purely objective criteria that you were using to select employees, you would expect the same ratios or percentages of protected characteristics to appear in the selected and non-selected groups that you have in the overall population. And when you do your analysis, if you look at the numbers and you see that, hey, there's a lot more Black employees have been selected for layoff than are representative of our entire population, you've got a potential issue. Because even though your selection criteria were neutral and were applied objectively and fairly, it somehow resulted in this unfair balancing of selected employees. And employees can assert discrimination claims based just on the statistics. So you need to then back out some of the selection criteria or adjust your criteria in a way that doesn't lead to a disproportionately large impact on any particular group. And it's a convoluted, complicated analysis, but experienced employment law counsel will be able to guide you through the process.
Great, thank you, Robin. And Jeff, back to you. Once the company has determined who it is going to lay off, how can the company implement layoffs to avoid any allegations of differential treatment?
Thanks, Stephanie. So implementation is obviously a complex topic. There's a lot going on, but we just want to cover a few of those things to think about when you're implementing a layoff. So obviously a high level 30,000 foot view topic or guiding principle that you should keep in mind is to make sure that everyone's treated equally in the implementation process. One of the things that every employer should consider and should consider early in the process are WARN notices. There's a federal WARN statute, and then also in various states, not every state has one, but there are mini warns, or what lawyers call mini warn statutes, that often mirror the federal WARN statute. The difficult thing about them from an employer's perspective is there are notice requirements in them. They vary by state and often vary with the federal WARN statute. Some of them are 60 days, 90 days. So you need to consider WARN early in the process, because if you wait until the last 2 or 3 weeks, you're not going to be able to abide by that notice period. So consider WARN early, the triggering requirements, how many employees you're laying off, all those things matter. And also make sure you consider the differences between not only the state and federal WARN, but also in each state that you operate, because there are differences even within the mini WARN statutes. Employers should also review employee entitlements, confirm that all impacted employees are at will and that they are not contractually entitled to notice or severance through an agreement, plan, policy, or practice. It's a really important thing to do as part of this process. If they are, make sure the notice or severance entitlement is met depending on the applicable contract or policy. Make sure any laid off employees receive any required state termination documents. These state statutes are growing. Again, there are differences between states. For instance, in New York, employers need to provide written notice of effective date of termination and cancellation of benefits, written notice of unemployment insurance availability, and New York Department of Labor record of employment. In California, for example, employers must provide notice of change in relationship, for your benefit brochures about unemployment benefits, a HIP notice about state payment of health insurance premiums for certain employees with high cost medical conditions. So these are just a few examples from states where a lot of employers obviously operate, but make sure you take those into account and look at them. And then you need to do some of the more basic things that most employers know about, but sometimes in the sort of rush to get things done, you don't really look at. So things like make sure you have the final paychecks for all wages, salary, bonuses, commissions, and other compensation is paid. If severance is offered, make sure you get a separation agreement and release. Make sure that separation agreement release complies with the OWBPA, the Older Workers Benefit Protection Act. And then an important part of this is the human element part of it. Implementing a process for the layoff that actually cares for your workers. So it's best to notify each employee being laid off in a meeting with that employee privately, if possible, virtual, if necessary in the current environment. After all individual layoff meetings have been conducted, then notify the rest of the staff about the reduction, but don't name individual employees. The staff being retained will want to know too if they're being laid off. So really think hard about the messaging, the order, and how you conduct these one-on-ones and then group messages to your workforce.
Thanks, Jeff. And Robin, I know we mentioned furloughs earlier, but we've been talking about layoffs. So if a company is considering furloughs rather than layoffs, does the company still need to be worried about these types of discrimination lawsuits?
Yeah, if you're not furloughing everybody, if you're not shutting down the entire company and you're going through a selection process of deciding who's getting furloughed and who's not, I think you've got very similar concerns because, as Jeff mentioned, there's the human element here, and so much of what causes employees to file claims is a perception that they're being treated unfairly or they're being retaliated against because of something they did or said. And so you do have to go through a similar analysis for furloughs, and the communications about who, the furloughs and why it's necessary and all of that are equally important for furloughs as they are for layoffs. Furloughed employees can go without pay for a long time. So that can do several things. Obviously the employees are distressed. There's morale issues that can lead to employees talking to plaintiffs' attorneys and looking for reasons why they are being treated unfairly, which can lead to claims. But also, you may have state and federal WARN obligations as well, because furloughed employees are not working, and hours reductions are sometimes a trigger for WARN. Even though the employment relationship is not terminated officially in a furlough, the reduction in hours over a period of time can lead to a WARN obligation. And you're going to want to go through the same process of having neutral, non-discriminatory, and consistently applied criteria in selecting who is and who isn't going to be furloughed. And doing all of that kind of prep work in advance, it's a lot of work. It requires some forethought and planning, but doing it will save you a lot of time, effort, and money on the back end, because if employees raise claims, you'll be able to easily show that the company acted reasonably and fairly in doing what it did.
Thank you again, Robin and Jeff. And for our audience, we hope you will watch all of the other videos in this series where we share insight into various employment related issues. So thanks again.
Yeah, thank you.
Thank you.